See, Article 11 is attempting to challenge a mindset that's been brought about by a political framework and a political system that's based on race and religion. Now, for a long time, that was never an issue when it came to matters of law and matters of rights. But what we've seen happening since maybe the mid-90s is a merging, I suppose I could say merging of those political interests with legal rights and legal interests. And where it's not politically expedient for certain things to happen, they don't happen anymore, even though those things are guaranteed. So the kind of problems we're seeing happening in court with cases like Sharmila, Murthy, and so on, are symptomatic of a very, very big problem. They're not localized, they're not specific individuals who we should sympathize with or pity and leave it at that. It's symptomatic of something far bigger, an undermining of a system.
I think the problems faced by many of the religious communities has gone on for the last 30 years. And the interfaith community, the organization to which I'm associated with, are firmly convinced that the path towards resolving inter-religious, inter-communal, national integration issues in this country would surely lie in the path of dialogue. That is the most important. And we have been engaged in that. And what has been happening is that we have discovered that more and more there are rules, regulations, policies that somehow do not take cognizance of the fact that there are religious communities, that there are sensitivities, and we need a place for us to address that. And we have exhausted practically every other, predating the Article 11 was the Interfaith Commission, and that didn't work out either. And we felt, therefore, we must go back to that one document that guarantees the rights of all citizens in the country, irrespective of religious affiliation.
On the surface, it just seems like a purely legal issue, something for the courts to resolve, which court deals with what. The fact that there is such a conflict arising, and that conflict has only arisen in the last 3 or 4 years, despite there having been two systems or two types of courts in existence for some time, to us indicates a creeping Islamization in the way the Constitution is being interpreted. So let me just explain that. So in the Sharmila case or the Murthy case, what we would have seen as having been simply resolved as this matter involving non-Muslims should therefore be within the civil court's jurisdiction, and that's how it's always been, was suddenly now being seen as being exclusively within the Sharia court's jurisdiction to the exclusion of non-Muslim parties, resulting in a deprivation of access to justice. So it's to address that unequal, some might say, application of constitutional guarantees and the concomitant deprivation of rights of access that the 13 NGOs got together and said something had to be done.
The way it is being portrayed by the critics out there, I think basically it is to find a common path through what is guaranteed in the Constitution to live together in peace, which has been possible until the developments, as Malik has shared, has come about, and therefore there is now a strict separation between the dominant religious community and all the rest.
You take Murthy's situation. So what we have now is a wife, a widow, who's not been given a chance to even suggest through legal means that her husband died a Hindu. And she's being told that she can't be unhappy about it. And we're being told that that's Islamic. Now, as a Muslim, I find that completely reprehensible, objectionable. But as a lawyer, I find it completely bewildering. So the question I've asked repeatedly is, what's changed in our system? Because looking at it from a clinical, detached standpoint, the law has not changed. The Murthy scenario happened in 1992. The Supreme Court in 1992, which is after the introduction of this, what some are calling the controversial 1211A amendment. I don't think it's controversial. Article 11, the group has never had a problem with 1211A. And although people are suggesting otherwise, we think it's perfectly all right provision.
Just tell us a little bit.
All right, 1211A is the provision which says that what is within the jurisdiction of the Sharia courts is not within the jurisdiction of the High Court. And that is the provision that is being used by the AG's chambers and Muslim lawyers who are arguing in favor of Sharia jurisdiction as providing a foundation for there being no jurisdiction in the civil court. So the Murthy situation, for example, you have lawyers arguing that because the question of status of a Muslim is within the jurisdiction of the Sharia court, it is not within the jurisdiction of the High Court, therefore the widow has no recourse. Now that's illogical. But the point I'm trying to make is, 1211A comes in 88. In 1992, we have a Murthy scenario unfold in the courts. A Sikh mother goes to the High Court of Penang and applies for an order declaring her deceased son as having died a Sikh. It was a fact that was not disputed that he had converted to Islam earlier on, but he had re-embraced Sikhism according to the mother. The religious authorities stand up in court and they joined issue, both sides presenting evidence as to whether or not, as a matter of fact and as a question of fact, that person had died a Sikh or a Muslim. So it went up to the Supreme Court, and the Supreme Court then, based on steps taken by counsel, had regard to a fatwa issued by the religious authorities in Penang. And based on what the fatwa said, and it was mainly guidelines how to resolve questions of fact on whether or not a person was a Muslim, the Supreme Court decided that the person had died a Muslim. But at no point in time was it ever suggested that the Supreme Court had no jurisdiction. So what we had there was ultimately both sides having their cases brought before the court and having it heard. And nobody could walk away and say that justice had been denied. So between 1992 and 2005, when Murthy passed away and the case became controversial, what happened? The law didn't change.